Quick reminder, the cases are the oral argument, unless we put an order down saying otherwise, oral arguments are streamed on the AOC YouTube channel, and then will be placed on the YouTube channel kind of the next couple days afterwards, just so you mind. Call the first case, please.
Robert A. Martin et al. v. Robert E. Martin et al.
We're here from the appellate when you're ready.
And, Your Honors, I'm reserving 3 times for rebuttal in this case.
I'm sorry.
We're reserving 3 minutes for rebuttal in this case.
That'll be fine.
Yes.
I thought
May
you
it please,
said 3 times.
Yeah, I did too. I thought you said 3 times.
I may need to say it 3 times.
I'm sure your argument's good, but we don't want to hear it 3 times.
Totally understand.
It was a bold approach, though.
May it please the court.
Yes.
My name is Matthew McClanahan. I appear for the appellants in this case, Robert Martin and Karen Martin. There are 2 issues before this court. First, whether the trial court erred in abusing its discretion in taking the extraordinary measure of striking all the defenses and assigning liability in this case against my clients. And 2, whether the trial court committed reversible error in finding that Robert E. Martin breached his fiduciary duty. Beginning with the first issue before this honorable court. As it relates to the extraordinary measure of striking defenses, it is one that does lie with the trial court. Judges have that authority. However, it is one that should be used sparingly. In the present case, the factual basis for the trial court's decision is simply not supported by the overall breadth of evidence. The court granted the plaintiff's motions for sanctions and other relief as it relates to providing an inventory and to submit to a deposition. The defendants were deposed on February the 10th, 2023, in keeping with the order of the court. However, no trust accounting was provided for. The reasons for that were provided in the trial court and enumerate a number of those. One, the reason to believe from a review of the facts and the evidence that was provided and the testimony at trial is there simply were no assets of the trust, that there were simply no assets that were ever put into the trust at any time. Therefore, to provide an accounting or an inventory of something that doesn't exist would be fruitless and would be pointless.
Except that you could have, they could have just done a report that said there are no assets, because otherwise they don't know that there's no, that's the whole point. What's in there, if anything?
Certainly, and Your Honor's point is well taken. And prior counsel for the Martins did, I believe, attempt to do that. It's in the technical record of the account. There was filed on December the 4th, 2019, defendant Robert E. Martin's accounting for the Martin Irrevocable Trust. Now, there was no certificate of service on that filing, and we have reason to believe that it was not necessarily transmitted to plaintiff's counsel. Nevertheless, it was an attempt to make that filing, and Mr. Robert Martin, the defendant in this case, shows, I think through his testimony, and that's been supplied of the record of this court, that he was consistently confused as to exactly what his roles and responsibilities were to be. The question then falls to the trial court is whether that assignment of blame should lie with Mr. Martin's counsel at the time, or if it should lie with him, and what behaviors go to such an extraordinary length to basically cause this to be a default judgment against the Martins in this cause. As I mentioned in my brief, and I would draw this court's attention to the March versus Levine matter, in which case it was a divorce case in which the husband refused to participate in any kind of deposition, despite being noticed into the hearing, and he lived out of the country, lived in Mexico, and the trial court denied the husband's motion to set aside the default judgment in that case, but the appellate court reversed the trial court's refusal to set aside the default judgment, saying this, that in that situation, it was simply too drastic a sanction for the husband's behavior. A husband's behavior that the trial court said that his testimony was unconvincing as it relates to his reasons why he couldn't participate and why he shouldn't be there. There's a strong preference in the state of Tennessee that cases should be decided on their merits and that they should be permitted to.
What's our standard of reviews to the trial court on this?
Your standard of review is whether the trial court abused its discretion.
Why was this an abuse of discretion?
It was an abuse of discretion because Mr. Martin did not have activities and culpability rising to the level to have such an extraordinary measure of him to have all of his defenses stricken and it be converted over
How
into...
many times did the court order him to provide accounting?
It was a number of times, Your Honor. It was a number of times. So I believe, I don't want to misrepresent to the court, but I believe it was at least 2 or 3. And I'm sure opposing counsel will have that number very handy. But it was multiple times.
I expect they may have the exact number.
That is probably so, Your Honor. It was a number of times, and we understand that. Now there were other factors that were going in amidst of this. I think that defendant's counsel at that time was undergoing some serious health concerns. Of course, it was in the midst of the pandemic and everything else that was going on in the world. Nevertheless, I think we do need to look to the fact of what damage actually was sustained by the plaintiff in this cause. And that goes to the second part of our argument today is this idea of did he breach a fiduciary duty by not providing an accounting. And the standard on that is set out multiple times in Tennessee law, but basically has 3 factors, 3 elements. Number 1, the fiduciary relationship has to exist. Number 2, a breach of that resulting fiduciary duty. And 3, injury to the plaintiff or benefit to the defendant as a result of that breach. As we look at the facts and evidence that's presented, we see that Mr. Robert Martin was in a trustee relationship, trust over his parents, his father also named Robert Martin. And that has to be shown that there was some sort of breach of that fiduciary duty. Now, in the drafting of the trust, it is interesting in the Schedule A that attached to the trust that there is simply one word, annuities. Now, Mr. Martin, my client, is probably like most individuals. Whenever you get one of those large trust packets, it's all legalese and it's very difficult to decipher and discern. And testimony was that basically he got this from the lawyer that drafted it and he sort of parked it in a safekeeping place in his home and probably never thought about it again for such a period of time. And he had provided testimony that he believed that the attorney that drafted the trust facilitated the transaction to put whatever annuities that were present there. But what was just simply on the Schedule A, it just says the word annuities, doesn't identify the company that the annuities were a part of, doesn't provide policy numbers or anything else. There were no means or mechanisms for Mr. Martin to be able to identify that asset and transfer it over into the trust should he have some sort of inclination to do so.
But aren't all these things what could have been set out in a trial? Aren't these defenses that you're talking about now?
These are defenses, but regrettably those were stricken as a result.
Yeah.
Of
So would you agree that unless we say the trial court abused its discretion on your first issue, we really don't get to the second issue?
That is true, Your Honor. Yes.
Okay.
That is correct. So yes, and just to kind of provide that in summation, and we can address the striking of the defenses in more detail. But as relates to the contractual interpretation of the trust itself, the important thing is that we interpret those documents just like any other contract by the plain meaning of those terms, and to understand what it was that was supposed to be in that document, what the expectations were. There was no proof that the plaintiff in this case that she suffered any financial damages that she suffered, that the defendant in this case, Mr. Martin, incurred any sort of benefit to himself. There was some testimony and evidence provided as it relates to an allegation of misappropriation of funds. However, the evidence on that is not clear in our estimation because, again, these individuals share a common name. Both are Robert Martin, and there was no handwriting expert or proof produced at trial that the signature on the withdrawals was that of Robert E. Martin as opposed to Robert A. Martin. Would go back and say this, Your Honors, if I may, in regards to the first issue. When it comes to a determination of striking these defenses, the trial court is tasked with making a clear and concise recitation of all of the evidence and all the facts that goes into striking of those defenses, providing basis for why it's taking such an extraordinary measure, and making sure that there is a clear and concise record to that effect and understanding why it was done. As it relates here, all of the blame for the resulting delays cannot simply be laid at Mr. Robert Martin's feet, but rather there are other and extenuating circumstances that we discussed earlier, whether it was due to the health concerns of both parties' respective counsels at various parts, and some other matters that's in the record of the court that don't relate exactly to the administration of the trust. A lot of the contentiousness of this case resulted from some successive temporary restraining orders that were put in place, and that contentiousness between those parties didn't really abate until after the elder Mr. Martin passed away in this case. I think that when we review the record and we take a look at everything that occurred in this case and what occurred and what actually happened, the trial court did not take any alternative actions. They failed to consider any sort of acceptable alternatives to striking these defenses. That final order doesn't weigh those factors in how it determined to take this as the appropriate action. There is some step less than basically granting a default judgment that could have occurred in this case in deciding that an appropriate sanction for discovery abuse was there. The factors that the court could have considered, should have considered, were one, the parties' reasons for not providing the challenged evidence during discovery; two, the importance of the evidence to the case; three, the time needed for the other side to prepare to meet the evidence; and four, the reasonableness of granting a continuance or some other mechanism for providing an expansion of time for producing that evidence here. With the death of the elder Mr. Martin, arguably the controversy was moot. At that point, without question, all the parties, but both parties would have been entitled to an equal, equitable interest in whatever assets were available to the trust, or in the alternative, even if he had died intestate, that they would have shared equally. Mr. Martin was unmarried at the time of his death. By the time that the elder Mr. Martin passed away, the need for any trust accounting or any litigation was made moot. A discussion of these factors, however, was not weighed by the trial court. And by failing to provide an understanding and weighing these factors, the trial court committed reversible error in failing to have those additional findings. In this case, should be remanded for additional findings of fact and conclusions of law. Thank you.
Thank you. You have your time for rebuttal.
Thank you.
Hear from the appellee.
Good afternoon, may it please the court. My name is Charles Gilbreth. I, along with my firm, represent the appellees, Ms. Donna Sass, and the now deceased Mr. Robert A. Martin. This appeal is about one simple issue. It's Mr. Martin's abject failure to abide by the court orders, the trust code, and the rules of civil procedure. All he had to do in February 2019 was give the accounting that was asked for, regardless of what was in that, whether it said there's millions of dollars or it was nothing. If he had given that accounting, we would not have had the need to go through all the litigation we did and necessarily this appeal today. But he didn't, and so we are here now. And this court should affirm the trial court in all respects for two reasons. First, the trial court did not abuse its discretion when it elected to strike the appellant's defenses after ample warning to correct its errors and begin complying with court orders and the law. And two, separate and apart from striking defenses, ample evidence was put forth at trial that supports a finding that Mr. Martin breached his fiduciary duties. There was live testimony given about what Mr. Martin did or did not do when it comes to providing accountings, making sure the trust is maintained, and his communications in that manner. And so
Let me ask you this. The document that's in the record that purports to be an accounting, how did that get in? Like, did your client ever receive it? When was it introduced into the record? When did it come in?
We did not learn about it until very late in the case when we were seeking sanctions for not having the accounting. And then it came to light that apparently in December 2019, something had been filed but was never served on us. But that accounting that was filed is still a red herring, Your Honor, because the information that was in that document it just wasn't correct. It cites to an annuity that was not in the trust, and it doesn't pertain any kind of tax or other information that's required to be put in there from the trust documents. I believe it's section 9.12 that tells what needs to go into the accounting. None of that was complied with. So, but had that been given to us, we could have pointed out back then, hey, this is wrong, let's figure this out. But then, importantly to your question, Your Honor, that was back in December 2019. the first order that went down for them to provide an accounting was in August 2021. So all they had to do would be, hey, we gave y'all one, or here's an updated one. But nothing of the sort was done. And then so what happened is, when you look at the facts and the procedural history of this case, it lays out much more than just simply the accounting issue. And that's why when you read the March 2 order, what the trial court relied on, the straw that broke the camel's back, so to speak, was the accounting. But it wasn't the only thing. When in August 2021, there's a temporary restraining order that was filed, and it was erroneously. The temporary restraining order had to be amended to even point out which account it was they were trying to restrain. When they did point it out, we explained to the court that account had already been adjudged to not be in the trust. So the TRO was dismissed and attorney's fees were awarded. And then we moved forward with trying to get discovery. And yes, there were some issues that happened because of COVID and because of illnesses, but we're not saying the entire 4-year history of this litigation is all at the feet of the appellants. We're not saying that. Of course, there were some delays, and that happens in any litigation. But there were substantial delays in the simple following of procedures. There constant that were never fulfilled. In 2022, there were multiple depositions that were noticed that were unilaterally canceled that led to ultimately the filing in January 2023 when we sought relief from the court to strike the defenses. In doing so, we pointed out the lack of discovery supplementation, pointed out the depositions unilaterally canceled, and pointed out that we still had not received the accounting. And in response to this motion, the court ordered the deposition, ordered an accounting, and ordered us to submit a fee affidavit. So there were other steps taken before finally issuing the ultimate sanction of striking defenses, because it wasn't until after the time came and went pursuant to the February 7 order to provide the accounting that we then had to come back to the court because they didn't do it. They were warned in that February 7 order, do this is the last final straw, give the accounting or I'm striking your defenses, and they still didn't do it. And as they point out in their brief and as they point out to the court, there's nothing there. And as Your Honor pointed out earlier, they could have said that. And particularly if they had said that in 2019, it would have saved everybody all the litigation, because then they could have, what's in there, let's figure it out, why is there nothing in there? But our clients were never given that chance. And then
were any depositions taken for, the court put the order down about depositions, any depositions taken?
Yes, they were, Your Honor. After the February 7 order went down, I believe it was February 10 or so is when the depositions finally took place.
Okay, the appellant was deposed.
Yes, Your Honor.
Was he asked there about an accounting?
Yes, he was asked there about it, and which leads me into the second point, to where he was asked about it, and it became clear that he had never once performed any of his duties as trustee, and to where he kept saying, I don't know what it is. Here is an update on an annuity that I think is in the trust. This evidence was not put into the record, however. It was just from that deposition. But so we had still wanted the accounting because it was clear that he was unsure. And so it was like, give us the accounting. You are the trustee. He is the one with the fiduciary duty to the beneficiaries to keep them up to date of what's going on, what is in there, what would my client be entitled to. And when we had the trial, even though the defenses were struck, shifting to the second point, even though defenses were struck, live testimony still went on that included some defense to their action. Because in the trial, we sought punitive damages because of the egregious breach of fiduciary duties, as well as what we thought was the conversion of assets. And so Mr. Martin took the stand, and he testified that, yes, he remembers receiving the request for accounting February 19, and that he didn't do anything about it. And he admitted also in his testimony that had he done something, maybe it would have obviated the need for the litigation. He further testified that once he got the trust, he threw it in his closet and never looked at it again. This man has duties and obligations under the trust code and the trust document itself to make sure the trust is funded, to make sure it's maintained, and to make sure beneficiaries are kept updated of what is going on and what they will ultimately be entitled to. And so he gave testimony that clearly shows that he breached his duties, separate and apart from whether the court struck its defenses to begin with. And then also in his capacity as power of attorney over the deceased Mr. Martin, he gave testimony about the transfer of assets. This course, the trial court listened to his testimony and said it did not pass the smell test. It said that in its experience, when someone takes the role of power of attorney and immediately starts converting assets into their own account, regardless of his hearsay saying his father told him to do it, it doesn't smell right to me. I don't find this testimony to be credible, and I don't believe it. And as this court knows, that the credibility determinations of trial courts are often not disturbed absent clear and convincing evidence otherwise. And there's not any of that here. His own testimony is what, in his own defensive actions, is what led to the ultimate ruling of the division of assets and the damage award at the end. And now, Mr. McClanahan brought up earlier about, the three elements for breaches of fiduciary duty, and one of them being damages. And, what's the harm? Because the elder Mr. Martin had passed away, everything would have been divided anyway. He's not entirely wrong, but the one thing that he's missing is the fact that by ignoring everything in February 2019, it led to 4 years of litigation and attorney's fees that our client had to endure. And that was the bulk of the damage award that was hit against his client. Because everything else, the annuity that everybody agreed should be in there, the funds that the court ultimately found were converted, those were split in half. They were still given, here's your half of the annuity, here's your half of the assets. So that's all well and good, and it would have been the ultimate result, except for the fact that we had to keep beating their head against the wall to make them do what the court told them to just let us know what was there so we could resolve things. And I don't have the date in front of me. I believe Mr. Martin passed away back in 2021, and this case didn't go to trial until November 2023. And so there's all this time where things could have been resolved, and all they had to do was just abide by the court orders and the rules of procedure, and they wouldn't do it. And so that's what led to all the damages in this case, and it's what led to the ultimate attorney fee award. I'm just going to read real quick, switching back to the first point, the trial court, in its ruling after the end of the trial, pointed out what I think matters a lot for this case with the actions that led us to where we ultimately ended up. And that's in the technical record, volume 3, page 420. In order to receive equity in Chancery Court, a party must do equity. But here, appellants blocked the way all through this. This court does not recall twice ordering somebody to do something that it did not put them in jail over. But it did not happen in this case because appellees never asked for it. They asked for a different remedy. The court did not reach this decision lightly. This court has not done it more than a few times in the last 18 years, and it's only when this court is unable to get compliance by any other mechanism, by sanction or otherwise, this court gave appellants ample opportunities to fix the problem. They never did, so this court awarded appellees at the request of relief and struck their defenses. The court reviewed the procedural history of this case. It looked at the repeated noncompliance, the unilateral decision to cancel notice depositions, and made the well-thought-out decision to strike defenses. But even setting that aside, the evidence that was adduced at trial still demonstrates there is enough evidence there that even if this court disagrees that the court overstepped its bounds with striking defenses, there was still enough evidence put forth at trial showing a clear breach of fiduciary duties, both as trustee and as power of attorney. And so for these reasons, we ask this court to affirm the trial court's ruling in all aspects. We also ask that this court award us our attorney's fees on appeal, either because the case law, such as the Duggan case that we cite to for the breaches of power of attorney, allow it, because the trust code allows it in section 1004, or because the appeal was frivolous. And unless your honors have any further questions.
I hear none.
Thank you.
Hear from the appellant, rebuttal.
Yes, Your Honors. As it relates to rebuttal of this, we would draw the attention of the court, as opposing counsel has directed, as relates to the February 7th, 2023 order. It was the proposed order granting plaintiffs' motion for sanctions and other relief. Trial court says in relevant part, it says that all outstanding discovery and provide a trust accounting to plaintiffs by February 3, 2023, and that plaintiffs shall submit themselves to be deposed by February 15, 2023. Without question, the deposition did occur, and at that point in time, Mr. Robert Martin, the younger, was deposed, was asked about the trust accounting, was asked about what information he had, and he brought and provided the information that he had available to him. I think that this is genuinely a case where Mr. Martin simply did not have a full understanding of what he was supposed to do as a trustee, and then moving through the case, did not have a full understanding of what his responsibilities were as far as that what was actually in the trust and what was to be provided. And it is regrettable that we find ourselves here, and this family has experienced this ongoing litigation and the hardship between the parties. And I think a
Let me ask you,
review.
Count,
Yes, sir.
I'm sorry. Are what we're really arguing about here as far as what was awarded would be just really the attorney fees because the other amounts were split?
Yes, Your Honor. I think that, any kind of punitive, yes, Your Honor. So basically, we just think that the award of the attorney's fees and the punitive damages and the striking of the defenses is excessive. I think, and if you look at the time that was involved in the case, much of it has to do with visiting the elder Mr. Martin. There were temporary restraining orders that were put in place whenever the elder Mr. Martin was in a skilled nursing facility, and there was an ongoing battle between the parties over his visitation and control over those assets as well that are not directly related to the role of him as trustee. We simply look at all of these issues before the court, and opposing counsels mentioned this idea of equity. In order to get equity, you have to give equity, and we understand that. But we also have to take the totality of the circumstances and everything that is put in place as far as what is an appropriate remedy, what are the factors that a court should consider, and based upon what the actual harm was that was incurred, does that justify the punishment, for lack of a better way to put it, that was imposed upon the defendants in this case, when we take everything into account and understand what the actual damages were. For those reasons, we think that this case should be reversed and remanded. Thank you.
Thank you. Of course, thanks to counsel from both sides. I hope you have a rain-free drive back home. Yes.